begin argument in Rich v. Herschel and Mr. Edwards.
Thank you, Judge Wilkinson, and may it please the court. A reasonable jury looking at all the evidence in the summary judgment record and drawing all inferences in Mr. Rich's favor could determine that on October 2nd, 2007, Daniel Herschel lacked probable cause to arrest Mr. Rich. Now, that is the key question before the court. All of the claims that Mr. Rich has asserted turn on, at this point, whether or not Officer Herschel had probable cause. Looking at the evidence, we see the undisputed fact that he had threatened Mr. Rich multiple times, that he had a motive to plant evidence on Mr. Rich or to make good on those threats. And the only truly disputed fact is whether or not Mr. Rich had a gun on October 2nd. Looking at the evidence in the light most favorable to Mr. Rich, the only person who claims to have seen Mr. Rich with a gun is Officer Herschel, whereas Mr. Rich and others around him, Mr. Rich directly denies having a gun, and others around him omit that fact from their characterization of the events. The district court erred when it granted Officer Herschel's motion for summary judgment, and we ask that this court reverse. My argument today is going to proceed in three parts, subject to where the court wants to take me. I'd like to start with the evidence, move into your decision in Elliott against Levitt, Judge Wilkinson, and then move to the statute of limitations issues raised in the red brief. Looking at the evidence and sort of piecing it together, we know—
You did wait a rather long time, whether it's formally barred by the statute of limitations, I don't know, but you waited 13 years to bring suit. If you got a— I realize if you got a strong case, you don't generally wait 13 years if you think there's an injustice done.
I understand your point, Judge Wilkinson, but I think the statute of limitations, no party has raised a laches defense. Officer Herschel had numerous opportunities to timely raise a statute of limitations defense, which is an affirmative defense that he was obligated to plead and prove under Rule 8C. And so, despite having that opportunity, he never took it. The city of Baltimore, the Baltimore Police Department moved—
It doesn't change the fact that you waited 13 years.
It does not, Your Honor, but I don't have an answer for that. I was not counsel below and don't know. I will say I think the triggering event may have been Officer Herschel's arrest in 2017. And then in 2020, so Mr. Rich brought the claim 3 years after Officer Herschel's arrest. I understand that is 13 years after the acts in question, but under the party presentation principles, I think that it was incumbent upon Officer Herschel to raise those issues below, and he did not.
Was there any evidence rebutting Officer Herschel's testimony that he saw Mr. Rich with a gun walking across the street and placing the firearm near or under a bush and walking away, and Officer Moss then confirmed that he was walking away from the bush. But there's no rule of evidence that says that a single officer's unrebutted testimony would be insufficient for probable cause, which itself is a lesser standard than beyond a reasonable doubt.
I agree in general, Judge Wilkinson, that a single officer's testimony may be sufficient, but in this case it is rebutted. Page 110, 111 of the joint appendix, Mr. Rich says he did not have a gun, and that is he said. But more than that, I think the witness statements in the record, joint appendix 165, 166, 167, all of those witness statements from Margaret, in particular the ones from Margaret and Michelle Crawls, and I think Margaret Crawls has since passed away, but Michelle Crawls, I understand, would be available to testify at trial, and she omits that.
What other explanation is there for the presence of the gun, other than Mr. Rich leaving it there? Was there any other explanation?
I think there is, Judge Wilkinson, yes. Officer Herschel had, we know, in June, in July, and on August 3rd, threatened to plant contraband on Mr. Rich. Specifically in 2 of those instances, he threatened to plant a gun on Mr. Rich. And then the latter 2 of those incidents also happened in the 100 block of North Bond Street, which is the same place that Mr. Rich was arrested. So he's repeatedly threatening Mr. Rich in the same location. Then I think there is the October 1st threat, which a jury could infer is Officer Herschel, based on similarity of the threats, similarity of location. And so you've got threats up to the day before Mr. Rich is arrested. And I don't think that it necessarily needs to be that Officer Herschel, maybe he did recover a gun. I don't think we can dispute that. I think my contention is that the gun was planted under the bush. I don't think Officer Moss's affidavit rebuts that. All he says at 102, 103 of the Joint Appendix is he saw...
What evidence do you have for that other than speculation?
Other than the threats, I don't have any direct evidence of that. I don't think we necessarily need direct evidence.
So if you don't have evidence of that, are we in a situation where someone could always say there's an issue in dispute, but the question is, under Rule 56, is there a genuine dispute of material fact? And if you only have speculation to support this alternative plant theory, wouldn't that justify what the district court did? Because there are lots of issues, but there are much fewer genuine issues.
I understand, Judge Wilkinson, but no, I don't think it justifies what the district court did. The district court had the evidence of the numerous threats, and again, it's not whether or not he planted the gun, but whether he had probable cause.
It's all circumstantial evidence, you're saying.
It certainly is all circumstantial evidence, Judge King, but again, there's no bar on surviving summary judgment with only circumstantial evidence. I think that happened.
Who passed away here?
Officer Herschel. Officer Herschel had terminal cancer and passed away in October. But
does that have an impact on you going forward here?
It does not. This court's decision in Dean against Shirer, 547 Fed 2nd 227. In that case, the court said that to determine whether a 1983 action survives the death of one of the parties, the court should look at 1988, 42 U.S.C. 1988. That supplies the state rule of decision. Maryland Code of
Don't
Procedure.
you have to substitute somebody?
We would need, the defendant would need to substitute. Under the Federal Rules of Appellate Procedure, the defendant or the administrator would be responsible for filing the motion to substitute. So there needs to be a substitution. I understand from my friend on the other side, the estate is not open.
Was the delay in some way linked to the, I hate to suggest it, but was the delay in this case linked to Officer Herschel's medical condition?
Do you mean the delay in bringing the case, Your Honor?
I mean, so that the delay, was it hoped in some way that the delay would prevent him testifying or make his testimony impossible?
I don't believe the delay was related to that. I think that the case was filed after he was incarcerated. I don't know one way or the other, and it's not in the record whether or not he had been terminally ill.
Judge King makes a point that what you have to do, what they had was direct evidence, and what you have is circumstantial evidence. And sometimes, circumstantial evidence can certainly suffice, but there's often a very thin line between circumstantial evidence and speculation. And the question I think you need to answer is, And why does this circumstantial evidence not fall on the speculation? Now, granted that circumstantial evidence is important in some cases, but in your case, why does it not fall on the speculation side of the line?
A couple of points on that, Judge Wilkinson. First, I think we do have we have Mr. Rich's statement contradicting Officer Herschel, and so we do have evidence that he did not have a gun. Other circumstantial evidence, I think the police reports that were recovered from Baltimore City, none of the other witnesses saw or mentioned Mr. Rich going to a bush. None of the other witnesses support Officer Herschel's narrative. Whereas Officer Herschel has repeatedly threatened to arrest Mr. Rich, and I think that is what nudges it over the line. I think this is very
But
different.
he's not here to testify now.
No, he's not, Your Honor. He is not here to testify, but that is, I think that is a concern for remand, just given the fact that we're here on a closed record, and he did give a deposition. I don't know what was in it, other than the few pages that were in the summary judgment record, but that would be admissible. Other statements that he made under Rule 804 would be admissible because the declarant would not be available. But again, I think that this case is different, Judge Wilkinson, to your point, from Elliott, because it's not just an officer saying, "Oh, this is what I saw." There was some other evidence presented that bolstered the officer's story. And again, the parents in Elliott, that argument that they raised was just that the officer's story was improbable. It wasn't supported by evidence. There was no one there to say, "Oh, my son didn't have a gun," because the decedent was the one with the gun. And so there was no direct evidence there that the individual had a gun other than the officer's story. The officer's story was corroborated by the autopsy report. It was corroborated by fibers recovered from the gun. It was corroborated by the fact that Mr. Elliott had been seen with the same gun. Here, it's a he said, and I think that throwing the case out of court based on a he said, it's not just circumstantial evidence. There is precious little evidence on Officer Herschel's side as well, and so he chose to come forward and say, I saw him with a gun. We've got a narrative.
Partially because of this 13-year delay, is it not?
Your Honor, I don't know whether or not it was due to the 13-year delay. All I know is the 13-year delay has never been brought up in a substantive way as a defense. And I would submit to the court that it's been waived, and it would be, and I hesitate to tell the court what it can't do, but under this court's precedent, if it's been waived, an affirmative relinquishment of that right.
It doesn't need to be brought up as a formal affirmative defense. It's still a factor that's in the case, whether it's a formal affirmative defense or whether it's not.
If it contributed to the lack of evidence, I think it's only relevant in that it.
The problem is that, memories fade and recollections are less precise and all the rest, and now we have the tragic situation of somebody dying of cancer in the interim, I think the major question you need to answer is, I'm still not clear that what you brought to bear on your side of the case it seems to have a real speculative quality.
Your Honor, I don't think so. I don't think it's speculative in the same way that I think the Graves case cited in my friend's brief is the statements are completely contradicted by the record there. The case the district court cited, Stravinsky, there's just no evidence, and so you're building inference on inference. And here, I don't think that sort of, when you talk about speculation, I think what it really means is, are you stacking inferences on one another? And here we have evidence that we have evidence that Mr. Rich didn't have the gun. We have evidence that Officer Herschel had repeatedly threatened to do just this to him. And that is, I think I concede in the opening brief, I think that's thin evidence, but I don't think it's speculative evidence. I think that's sufficient evidence to nudge it over the line to allow a jury to make that inference, because to Judge King's point, We try cases based on circumstantial evidence all the time. And to your point about the evidence, the quality of the evidence fading, memories fading, again, that is the policy rationale embraced by the statute of limitations, and I think that the court...
So you say, well, he in the past he did this and he did that and everything, but that doesn't speak to this particular case.
No, it does not speak to the case, but I think that the fact that there is... I see I'm out of time. May I respond?
You have some rebuttal.
Yes, Your Honor.
Good morning, Your Honors, and may it please the Court. My name is James Corley, and I and my colleague Michael Redmond are here on behalf of appellee Daniel Herschel. Your Honors, the Court should affirm the lower court decision because the plaintiff has presented zero evidence that contradicts the idea that Mr. Herschel recovered a gun. My colleague says that the only fact that is in dispute is whether Mr. Rich had a gun. That is not true. There are two facts in dispute, whether Mr. Rich had a gun and whether Officer Herschel previously threatened him. But we have to take those threats as true at the summary judgment stage. But it doesn't change the fact that simply because he had threatened him on a prior date, Mr. Rich has presented no evidence as to how the gun got there. What we have is uncontradicted testimony from Officer Moss that they were on top of a roof, that Officer Herschel said, "I see Mr. Rich with a gun," that Officer Moss turns around and sees Rich walking from the exact space that Herschel said he was coming from and where they are.
He did not see a gun.
Correct,
Officer
Your Honor.
Moss did not.
That is correct. He did not see a
The
gun.
person who saw the gun was Herschel.
That is
Who
correct.
was the person who they allege threatened to plant a weapon on him, correct?
Allegedly, yes, Your Honor.
Well, everything is allegedly, right? And at this point, what inferences do we draw in favor of?
You're correct, Your Honor. We have to take the threat as true that Herschel had previously threatened to plant a gun. However, there is no evidence to suggest that a gun was not recovered, and Mr. Rich...
That is evidence to suggest. That is evidence. In other words, it says, "I'm going to plant a gun on you." 2 months later, you said, "Oh, I found a gun you put in the bushes." That's not evidence. Now, the trial of fact would have to decide that, but that's certainly evidence.
I don't dispute that Mr. Rich's testimony is evidence, Your Honor, but Mr. Rich does not contradict that a gun was recovered, and in his briefing has acknowledged that it is entirely possible that Herschel recovered a gun and misattributed it to him. The gun does not have to be Mr. Rich's. The standard for probable cause is whether an officer, based on the totality of the circumstances, has reason to believe that the suspect has been involved in criminal
Didn't
activity.
Mr. Richard say, "I didn't have a gun, I didn't put a gun there"?
Mr. Rich has said that, yes.
Okay, I didn't put the gun there. He said it, threatened that he would plant it, or there's evidence of that. What is the fact that there was a gun there, found there, counsel that? I mean, if you plant a gun, I'm just saying that, and I didn't have one, a gun would still be there. You act like just because the gun was there, it means clearly it doesn't make any difference. It's still connected in terms of circumstantially.
Your
So
Honor.
I tell you, if I was gonna plant a gun on you, and then 2 months later, I said, "Oh, here's a gun here. I found it in the bushes," and you said, "I didn't do it." You're saying that, matter of fact, motive is always an issue, right, in prosecuting cases?
Under 404, yes, information about a person's character or their threats can be used to prove motive, but Mr. Rich has not presented a motive for planting a gun in this case. He's said that that Herschel threatened him, but there's no reason for Herschel to especially if Herschel's trying to get him to become a confidential informant, he would have no reason to undermine his credibility by planting a gun on him.
But this is a strange case. I'm surprised Mr. Edwards didn't even mention it at all. Is this the usual case here with a police officer?
Absolutely not, Your Honor. And
Absolutely not. And talk about speculation. Is speculation that he said that someone said that he would plant a gun on them? Is that speculation in terms of the whole context of this case?
well, Your Honor,
That's the question. Is that speculation? Because Judge
it
Wilkinson said this
is
is
speculation as to whether the gun was planted, because all Mr. Rich can say is, "I did not have a gun." He does not present any testimony as to how the gun got there, whether Mr. Herschel was in the area at any time prior to the recovery of the gun. No, there's no fact saying that I saw Herschel with a gun prior to the arrest. What you have is Mr. Rich saying, I didn't have a gun.
So the criminal convictions in the past make no difference in this case, you're saying,
Which criminal convictions, Your Honor?
involving police activity?
Well, there's no evidence in this record as to prior criminal convictions. The only criminal convictions related are either the 4 prior convictions that Mr. Rich admits that he had in his interrogatory answers on record at page 110, including possession of a firearm, and he acknowledges that Officer Herschel and Officer Moss knew of his prior contacts. So
at
they
a
have.
trial, would that be admissible, you think?
I'm not sure, Your Honor, but it's not relevant, because the issue here
It's
is
not
what
relevant
is
because
it?
you're saying that we'll take all the inferences in your favor. You're right, if you say, we'll discount that he said that he didn't have a gun. We'll discount that somebody said that he was gonna plant a gun. If we discount all of that, you're right, there is no case. But you're drawing all the inferences in favor of your client, aren't you?
I don't believe so, Your Honor, because I'm accepting the fact that if we accept that Herschel threatened Mr. Rich, all we have are statements from prior dates. There's no allegation or no evidence that he ever acted on those threats.
Well, every threat is prior.
But without,
Do you know if a threat is not this afterwards?
I understand you.
They're all prior. I mean, it makes no sense. I mean, it's prior. And the actual thing that he said he was threatened to do, lo and behold, that's what happened. Oh, you had a gun. I don't understand the disconnect in terms of the inferences drawn there. I understand you represent your client and you're doing a good job in terms of advocating for him, but our role here is not to just do away with, for example, why didn't you assert statute of limitations?
Your Honor, candidly, I did. I represented the other 14 individuals at trial. Mr. Herschel hired
Like I said, you only have one client here today. Why didn't you file something?
I cannot speak for why.
So you can't even speak for that, right?
I do not know why Mr. Herschel would not have filed a statute of limitations defense. I know that
And you agree with party presentation, right? It's very important. Supreme Court, I can tell you, recently said that's important. Prior presentation, party presentation, right?
Yes, Your Honor, but the issue is whether or not the court and the opposing party have the opportunity to defend against the issue. If the issue was never raised and Mr. Rich did not have the opportunity to present a legal argument, that would be one thing.
The Supreme Court has said time and time again that probable cause is a distinctly different standard from beyond a reasonable doubt. And you're not in the business of trying to try an individual prior to making an arrest. The Supreme Court has said we do not want to construct a high bar out of the probable cause standard. And the question is whether a reasonable police officer had a reason to believe that it was more likely than not that individual, Mr. Rich, was in possession of a gun. And how could it be anything other, in light of the observations that the officer made, how could it be anything other than a reasonable belief that it was more likely than not? We're not asking for certitude, we're not asking for a definitive conclusion to something. We're simply asking whether it's more likely than not that Mr. Rich was the owner of the possessor of the gun. And how could it not be in light of the observation?
Your Honor, I agree with you. The other issue here is the fact that there were at least 11 individuals in this area. Mr. Rich himself, he states that 5 police officers arrived, including Moss and Herschel. He identifies 4 individual friends he was with, as well as Mrs. Crawls and her daughter. There's no evidence as to how the gun got there. So assuming that a gun was recovered, it was either Mr. Rich's, it was one of his friends, Officer Herschel planted it, or a unknown third party planted it. The only thing that happens when Mr. Rich says the gun isn't mine is he makes number one in dispute, whether the gun was Mr. Rich's. Him saying, I didn't have a gun, does nothing to prove or disprove whether the gun was his friend's, whether Herschel planted it, or whether someone else did. And the fact that he has a complaint, he filed a complaint against Officer Moss on about 2 weeks prior to this arrest, claiming that he was going to threaten him, or that he threatened to plant stuff on him. Moss is in the area as well. So why say, Herschel threatened me, I had a gun on me, so Herschel must have planted it.
He doesn't have to own the gun. The question is one of possession.
Correct, Your Honor. It doesn't even have to be his ultimately. The trier of fact can determine that it wasn't his. It's whether Officer Herschel at the time.
Excuse me, but ownership is not an issue. The only thing that's his issue is possession. And when you have the combined testimony of Officer Herschel and Officer Moss, and particularly with Herschel, that someone had a gun, put it under a bush, walked away. Moss confirms that to the limited extent that he saw him walk away. The question is it more likely than not that he was the possessor? Whether he's the owner or not doesn't matter. The question is, under the probable cause standard as it's been articulated by the Supreme Court, is it more likely than not that Mr. Rich was the possessor? Well, common sense will tell you, and common sense is supposed to feed into probable cause. Common sense would tell you, yes, it's more likely than not that he was the possessor. That's all that's at issue.
That is correct, Your Honor.
Well,
And
that's
in
not
this,
true, Counselor. That's not all this issue, is it? The question is really an issue in this case. I don't know why I avoided is the honesty of the police officer. And it's in question. This is not a case where we're saying, oh, did the police officer actually make a mistake? Or is this probable cause? The question here is the honesty of the police officer. And there's evidence that they allege that he was going to plant a weapon, and also in terms of conversation with another person about a weapon before the situation, made complaints. It's the honesty of the police officer. So what would be the question is that, I guess, my dear friend Judge Wilkinson would say that you would have no defense in any case where a police officer says you had a gun. Well, you had the gun. Well, no, I didn't have the gun. And he said 2 months ago he was going to plant one on me. And all the court would have to say, well, that's what you said, but we don't look at the honesty of the officer at all when you have other people who said otherwise. This is not the run-of-the-mill case.
I agree, Your Honor. One of the things that needs to be noted, though, is that Mr. Rich's allegations that Officer Herschel planted a weapon on, or that he threatened to plant a weapon on him, none of those exist in the record anywhere until the day after his arrest. Conveniently, Officer Moss arrested him on September 10th, and on September 21st, Rich called IA and filed a complaint saying that Officer Moss threatened to plant something on me. Officer Herschel arrests him on October 2nd for possession of a gun, and on October 3rd, Mr. Rich has his girlfriend call IA and say he's been threatening him for months. There's nothing in the record that shows that any allegation of a threat to plant any weapon on him was made until after the fact. So what Mr. Rich is asking this court to hold is that any plaintiff who is arrested for possession of a gun, if after they're arrested, they simply say, he threatened to plant that on me last week, that alone, that self-serving, uncorroborated statement, is enough to defeat summary judgment. That is what Mr. Rich is
But
asking.
this is not any officer case, is it?
Based on the record, I think we need to distinguish what is in the record here, Your Honor, and what is in the zeitgeist. Obviously, the GTTF looms large over this case. However, Mr. Rich has to put evidence before the court as to what he wants them to consider. And there's no evidence in here of any crimes against Mr. Herschel that are relevant. Mr. Rich, in his opening brief, states that while Officer Herschel was convicted of racketeering in 2018, he specifically states his racketeering crimes do not appear to have started until 2014 or 15, 7 years after this arrest. Mr. Rich has put nothing into this record aside from his own allegations that Herschel threatened him. That's the only thing in the record as to Officer Herschel's credibility in this case. And we have to be limited by that record and what the plaintiff puts before the court in a Rule 56 motion. I'd like to address your issue as the statute of limitations, Judge Wilkinson. As noted, Mr. Herschel's counsel at the lower level did not raise that. However, it was raised by 14 of the 15 defendants, and it was opposed by Mr. Rich and argued. And the court found that it was statute barred because at the time that his charges for possessing a gun were null prost, he knew that he had a claim. And he did not bring a claim for 13 years. Judge Hollander ruled that the case was time barred, and Mr. Rich has not appealed that finding. The question is whether or not this court can use that as an alternate ground. And it can, to prevent a manifest injustice. In this case, you have the city of Baltimore funding a defense for an officer who is now deceased. You have one of the primary witnesses that Mr. Rich points to is also deceased. And all of the testimony before the court from Ms. Brown and Ms. Crawls is from unsworn, unauthenticated summaries written by another detective after the fact.
You're saying we have to decide that this was a manifest injustice to let him proceed at this stage?
I'm not saying that you have to, Your Honor. I'm
No,
saying
but in order to grant relief under statute of limitation.
I'm saying that the precedent of this court says that you can affirm the lower court's decision on any grounds that's readily apparent from the record. And it is very clear from the record that there's been a judicial finding that the case is time barred, and Mr. Rich has not appealed that finding. So to the extent that there's a question.
And you say Judge Hollander made that finding?
Judge Hollander made the finding that it was time barred, and this court in the case of Demetric Simon relied on that finding to hold the same thing, that if a person is arrested for the possession of a firearm, when their case is null prost, at that moment is when their case accrues because they knew that the gun was not theirs if it wasn't. So in this case, if the court does not want to deal with the issues of the threats or anything else, there's a judicial finding on the record that the court can fall back to that the case is time barred. And the idea
But
that
not
we...
as to him personally.
The case is time barred as to everyone, Your Honor. The dates don't change. Whether the
Well, there was a finding as to him individually?
there was a finding
No
that
motion was made for him for statute of limitations.
that is correct, Your Honor.
Why
But
are you saying that as a judgment as to him? That's not true as to him individually.
I didn't. I apologize if my statement was unclear. I'm not saying that there was a judgment in his favor. I'm saying that there was a
The
judicial
judgment-
finding on the record that the case itself is time barred.
On the same set of facts?
On the exact same set of facts. The dates that Mr. Rich was arrested and null prost do not change between the defendants. And 14 of the 15 defendants were dismissed because the case was filed well after the statute of limitations. Under the Local Government Tort Claims Act, the city of Baltimore is required to provide a defense for Officer Herschel. In this case, I'm defending him. In the lower court, we paid for his defense.
But his case wasn't dismissed.
Excuse me, Your Honor?
His case was not dismissed.
Correct, Your Honor. And
do we know why? Maybe there was a reason that it wasn't.
I cannot speculate as to why he did, but there is zero tactical reason why a diligent defendant would not have their case dismissed at the motion to dismiss stage and choose to go through litigation for 2 years on a case that is time barred, other than his attorney failed to file a relatively simple defense. And in this case, the court is allowed to affirm on those alternate grounds, and you can disregard any waiver or forfeiture based on the fact that
You have a
moving...
case that says that?
I do, Your Honor.
But you didn't, right.
Court's indulgent for one moment. In this case, this court itself, in 3 different cases, Helping Hand in 2005, Rice versus Rivera in 2010, and U.S. v. Holness in 2013, has said that this court retains the inherent authority to consider and decide matters that otherwise may be ignored as abandoned or waived, and under appropriate circumstances can disregard a party's inattention to a particular issue. If this case is remanded, it's going back to trial with a dead defendant, a dead witness, inadmissible hearsay as to anything that is testified to other than Mr. Rich's testimony. What Mr. Rich is asking is...
You can't forecast what the trial is going to be.
Well, I can forecast that Ms. Crawls is, as Mr. Rich has declared her deceased in his interrogatory answers, her testimony cannot be resolved into an admissible form. She did not give a deposition. She did not give an affidavit.
When you
and the-
waited 13 years, the chance, we're not talking about 5 years, we're not even talking about 10 years, we're talking about 13 years. And when you wait that long, the chances of a just decision and a fair decision diminish substantially. And the chances that the decision is going to be characterized by, well, in this case, we have a deceased witness. In other cases, we have hearsay and recollections fade and everything. This is, I cannot recall something where an arrest was made and it was 13 years before something was filed. And during that period of time, the chances of an accurate determination and a fair determination diminish substantially.
I agree, Your Honor, and I see my time is up.
Yeah.
Thank you, Your Honors.
Mr. Edwards?
Thank you, Judge Wilkinson. Just a few points on rebuttal. I want to start with the statute of limitations issue you brought up, Judge Gregory. This court's acknowledged that for years it has used waiver, forfeiture, abandonment in sort of an interchangeable way. The Stokes decision we cite clearly defines waiver, clearly defines forfeiture. Waiver is a knowing relinquishment of a right. And here, there is no question that the right was all over the docket and in Herschel's face, and he never moved to dismiss on the basis of the statute of limitations. That's waiver, and the court cannot set aside waiver. Even if it's forfeiture, Lavabit says that that standard is higher than plain error in United States against Delano, and I don't think that they've shown that here. Finally, Lavabit talks a lot, In re Underseal talks a lot about the respect due to district courts. The district court found that this defense had been waived. The district court said you cannot assert it because you slept on your rights. And my friend has not tried to explain why that decision is wrong. And so I would submit to you that affirming on the basis of the statute of limitations would be trampling on the district court, and it would be violative of the party presentation principle. I am sensitive, Judge Wilkinson, to your concern.
It would be overturning a district court on a matter that was not raised before the court.
That's right. It was never ruled on the merits.
The question of whether it is formally asserted as an affirmative defense, that means we wouldn't do it on that ground. But on the other hand, it makes no sense to say that we must entirely ignore a fact that, as far as I can see, is undisputed from the record, that it would, that 13 years transpired between the arrest and the filing. Now, we just supposed to close our eyes to a fact in the record? It may be waived as a formal affirmative defense, but that doesn't mean you read something out of the record. And the record here shows a delay that is simply bound to compromise the quality of justice that is rendered on a remand. It is bound to compromise what we're all about, which is to have accurate, fair, and balanced decisions based on the evidence.
Respectfully, Judge Wilkinson, the court is supposed to resolve the arguments put to it by the parties, and that argument has not been presented below, and so it would violate the party presentation principle. The court has said it can set aside party presentation only if it needs to get to some fundamental underlying legal question, so it can't get the law wrong, but this isn't asking, I'm not asking you to get the law wrong, I'm asking you to hold Officer Herschel to his failure to assert this defense.
He's dead.
And his
What kind of trial is that going to be? The man is dead.
Your Honor, the trial management issues are for the district court, not this court. If
Does a 1983 claim survive?
it does. Maryland Judicial Code
That's governed by
6401.
Maryland law?
Yes, Your Honor, it does. Judge Wilkinson, I also want to address two other points I think you raised. One is probable cause. Herschel never raised below the prospect that the gun might be somebody else's, that the gun, he says the gun is Mr. Rich's. And so even if we accept that he found a gun, the dispute is whether or not Mr. Rich had the gun, and Mr. Rich said he did not have the gun. And so it's not just about whether he sees the gun, but whether he can reasonably tie Mr. Rich to the crime of possessing a firearm by a felon. And just saying, I saw it, we've got a he said. And I think my friend is asking you to draw inferences against my client by ignoring his statement and elevating Herschel's.
There's always a flat denial, but the question is, there's a flat assertion. But the question is, what's behind the flat assertion? Is there some foundation to the flat assertion? Is there some evidentiary basis for the flat assertion?
There's no basis for either assertion, then, Your Honor. I think that Herschel's assertion is, I saw him. Moss doesn't credit that. We don't dispute that he walked from the west side of Bond Street to the east side of Bond Street, which is all Officer Moss says. Herschel is the only one that can support the inference he has a gun, but all the other witnesses, all the other statements given to police omit that he dropped a gun near a bush. Everybody says, I never saw a gun in these other statements. Finally, yes, there is a motive. Herschel had threatened Mr. Rich, and Mr. Rich had called the Internal Affairs Division.
Thank you, sir.
Thank you, Judge Wilkinson.
Let me ask my colleagues if they have any questions.
I do. I'd like him to finish what he was about to say about the motive.
The evidence in the record suggests, Judge Gregory, and I think it's 160 through 170 of the Joint Appendix, that Herschel had, not only had he threatened him, but when he threatened Mr. Rich, particularly on August 3rd, Mr. Rich called 911. And so Herschel knows that if he's trying to, maybe he's originally trying to get Mr. Rich to go state's evidence, but by the time we have this 911 call, by the time of the August 3rd interaction, he knows Mr. Rich is reporting him up to his supervisors. And so you've got motive, you've got threats, and you've got a dispute of fact about whether or not Mr. Rich planted the gun or had the gun. And I think that's enough to send the case to trial. We'd ask the court reverse.
Judge, do you have any further questions? We want to thank you both, and we'll come down and greet counsel and then move directly into our next case. Richardson versus Frame.
Good morning, Your Honors. May it please the court. My name is Jonathan Byrne. I'm here this morning on behalf of Raymond Richardson, the petitioner below. In 1948, the Supreme Court said that no principle of procedural due process is more clearly established than that notice of the specific charge and a chance to be heard in a trial of the issues raised by that charge are among the constitutional rights of every accused in a criminal proceeding in all courts, state or federal. That's precisely what happened in this case. State charged that Mr. Richardson committed robbery in one particular way and then proceeded to convict him of committing it in a different fashion. That violated Mr. Richardson's right to due process, and ultimately, as a result of ineffective assistance of counsel on part of his trial counsel, and this court should vacate his conviction.
This implicates what, counts 3 and 4?
Count 3, Your Honor, yes.
Well, counts 4 is related to it too, I think.
It's mostly count 3. Your Honor, count 3 was the robbery charge.
The question is notice,
Yes, Your Honor, that's correct.
and the grand jury clause doesn't apply.
Correct, Your Honor. Yeah, it's a due process claim through the, it's kind of a nesting doll situation. It is at the core a 14th Amendment due process claim.
It's the 14th Amendment rather than the 5th Amendment.
Yes, and then it's ineffective assistance of counsel. That's how it was raised in the state court habeas proceedings. That's how it,
6th Amendment claim through the 14th.
yes, or 14th Amendment claim through the 6th,
Whatever.
one way or the other. So in West Virginia, there are 2 forms of aggravated robbery. There's one that involves actual violence. There's the other that involves the threatened use of a dangerous weapon or firearm. Mr. Richardson was charged in his indictment with the second variety of aggravated robbery. But when the case proceeded to trial, the state switched its theory and prosecuted him on a theory of actual violence. And that started in the opening statement. It went through the evidence developed through the victim in the case, Ms. Cool, and eventually transferred into the judge's instructions to the jury, which allowed the jury to convict on either theory. Mr. Richardson's trial counsel failed to object to any of this. During the state habeas hearing, he admitted that he missed it, that he should have challenged it.
Lots of times lawyers don't object for strategic reasons.
In some certain cases, that's true, Your Honor.
Well, absolutely.
There's no indication that that was done here because trial counsel admitted that he simply missed the issue. He did not testify that there was a strategic consideration in not raising it.
Well, Judge Copenhaver here, who is a district court, correctly identified the standard of review, did he not, that in a 2254 case from a state judiciary, or from, in this case, the West Virginia court, there was a double standard of deference, both to the trial counsel and also to the West Virginia courts, which would have had to have engaged in an unreasonable application of clearly established law as determined by the Supreme Court for us to grant relief.
That's correct, Your Honor.
But I'm just saying that Judge Copenhaver correctly identified what the standard was in reviewing the West Virginia decisions, did he not?
He did, Your Honor. And I think where Judge Copenhaver...
How do we get around that?
Well, I think where Judge Copenhaver made a mistake was in giving too much deference to the state court determination of the facts, which our position is that it's an unreasonable conclusion based on the facts, because the state court habeas decision on which Judge Copenhaver relied said that Mr. Richardson and his counsel knew that the state was going to proceed on this theory, but the state court order making that finding doesn't cite to any part of the record to support that. And if you look at trial counsel's testimony during the hearing in front of the state habeas hearing, he says twice, I believe, that he should have challenged the validity of the indictment, that he missed it. And Mr. Richardson testified specifically that they were surprised when the state's theory changed on the day of trial. And that's what makes this case distinct from the Barbie, I think it's Barbie, decisions that the state relied on and that Judge Copenhaver looked to in his decision, because in that case the state actually got an amendment to the indictment prior to trial. So when trial started, everybody knew what the playing field was. That is not what happened here. Mr. Richardson went to trial on a particular theory.
How could they be surprised? The indictment indicted him for first-degree robbery. That was what he was tried on. That was what he was convicted on, and it didn't, the case didn't really turn on whether there was a force or a threat. But it turned on whether the defendant ever took the money. That was his defense, and that was a defense to the armed robbery count. But the cases are fairly uniform, that a variance in the means by which a crime is committed is not an impermissible variance. So whether this was done by violence or whether it was done by a threat, all of those are questions of the means by which the crime was carried out. But as long as the crime itself was indicted and charged, and as long as the conviction was returned on what was charged, there's been no impermissible variance, notwithstanding some sort of argumentation about what means were used to carry out the offense. I mean, isn't the law so well established on that point that it would be hard to say that the state courts impermissibly made an unreasonable application of clearly established federal law? They seem to follow federal law. How can following federal law be an impermissible application of it?
Well, the state court certainly cited federal law, but I would take issue with the idea that it's necessarily clearly established that you can have a charge that says you committed a crime in manner A, and they prove manner B, and that is not an issue. And I would point the court to, there were a couple cases we talked about in our brief, O'Day, which is out of the Sixth Circuit, and Coakley out of the Eighth Circuit. And Coakley particularly, I think, is very similar to this case. That was a situation where the defendant was charged with rape. He was charged with rape based on acts that involved sexual intercourse. The victim testified at trial. She said acts included sexual intercourse and oral sex.
But the indictment cited the proper offense, and the jury convicted him of that very offense. That's the nub of it.
But the offense that the indictment charged is not what the jury convicted him of. If all that's necessary is that there be a statutory citation, then the rest of that indictment's basically surplusage. And I don't think that's true, because it has to provide some notice as to what the theory is, or at least the state chose.
Well, Judge Copenhaver says he received actual notice, and that the actual notice was sufficient. That was his ruling.
Yes, Your Honor, and that's the ruling that's based on the state court decision that doesn't have any citation to the hearing that the state court conducted. The state court says Mr. Richardson and his counsel had actual notice, but don't point to where that conclusion comes from. And our position is if you look at the transcript, Mr. Richardson and his counsel both say the opposite. And so that's an unreasonable determination of the facts as relates to the habeas hearing. So going back to the cases that I mentioned from our brief, they both stand for the proposition that you can have this situation where the theory changes after the case starts, and that can be a due process violation. And Coakley, particularly, and the discussion is on pages 19, 20 of our brief, lays out really why it is not enough that the parties kind of knew what all the facts were, therefore none of this was a surprise. The question wasn't what the facts were that could support a charge, it's what the state said the charge was based on. And so once the state says, we're going to charge you with offense A, they cannot then switch to offense B. As much as I still have time left and I feel like I should be saying something, unless there are any other questions, I'll save my time for rebuttal.
Thank you.
Thank you,
We
Your
have
Honor.
some rebuttal time as well. Ms. Wilson.
May it please the court. Petitioner in this case was charged with first-degree robbery and convicted of first-degree robbery. But because the means in the indictment differed from the evidence in the instructions at
You're
trial,
referring to which counts of the indictment?
in count 3, he was charged with first-degree robbery, and in count 4, he was charged with assault in commission of a felony, to wit, first-degree robbery. So the two are related. But because the means in the indictment differed from the evidence and instructions at trial, petitioner wants habeas relief on an ineffective assistance of counsel claim. Petitioner faces a formidable barrier. When AEDPA meets Strickland, this court pays double deference to the state's decision. And the only question before this court today is, did the West Virginia Supreme Court of Appeals unreasonably apply Strickland? The answer is no. The state court was right on both prongs of Strickland. There was no broadening of charges. Petitioner had full notice. He suffered no prejudice.
Which state court are we deferring to? The state trial court or the state Supreme Court or what?
Judge Wilkinson, this court looks to the last state court that addressed the merits of the issue. So in this case, it would be the West Virginia Supreme Court of Appeals.
There was no state habeas proceeding?
There was a state habeas proceeding, and the trial court decided the habeas issue, and then it went up to the West Virginia Supreme Court of Appeals.
Okay, so the state habeas proceeding went up to the West Virginia Supreme Court.
That's correct, Your Honor.
And the operative decision is that of the West Virginia Supreme Court.
That's correct, Your Honor.
Was it unanimous?
Yes, Your Honor, it was a unanimous decision. So there was no broadening of charges. Petitioner had full notice. He suffered no prejudice. And even if this court could rewind the clock, the defense and the outcome would have been the same. So the state asked that this court affirm. I'll begin with the deficiency prong of Strickland. Trial counsel never had a meritorious argument to begin with, so his performance could not have been deficient. And it was reasonable for the state court to conclude that trial counsel was not deficient. When it comes to the 14th Amendment, and I think Judge King put his finger on the right issue here, the lodestar really is...
How do you explain the fact that the counsel seemed to say was insufficient or ineffective?
I think Your Honor is referring to when...
Is he trying to help his client?
I don't believe so, Your Honor. I think you're referring to when counsel said that he missed the issue. Is that correct? Well, he did say he missed the issue.
I'm not here to answer questions.
I understand, Your Honor. I understand. Counsel did say that he missed the issue, but frankly, there was nothing to miss, and that's because the indictment comported with the 14th Amendment and its due process requirements. The indictment was sufficient for 3 reasons, really. One, there was no broad...
Well, the magistrate judge disagreed with the Supreme Court of Appeals, and he recommended that the fellow get relief.
That's correct, Your Honor, but the magistrate court...
And then they made a report to Judge Copenhagen.
That's right, Your Honor. Judge Abelhausen actually...
Who refused to declined to go along with him, but gave him right of appeal.
That's correct, Your Honor. The magistrate judge, though, incorrectly applied a line of cases regarding the Fifth Amendment, the Sterone line of
So
cases.
the magistrate judge missed it.
Yes, Your Honor.
He thought the Fifth Amendment applied,
That's right, Your Honor.
and the grand jury clause of the Fifth Amendment doesn't apply. It's never been.
That's correct, Your Honor. The 14th Amendment is the applicable standard here, and it's much more flexible than the Fifth Amendment. The 14th Amendment deals with notice and fairness, and really that's why when we, these cases, when we're dealing with state court indictments, don't usually come up because they have to make the trial so egregiously unfair, and that is language straight out of Ashford v. Edwards, a decision by this court. And as I said, the indictment doesn't run afoul of these notice and fairness issues for 3 reasons. No broadening of charges, the petitioner had actual notice, and third, the petitioner wasn't prejudiced or hampered in his defense. So-
What counsel said that he should have made an objection to the variance, right? That it was a
That's
fatal
correct,
variance. That's what he said. I should have made an objection. It was my error.
but critically, Your Honor, Strickland cases aren't viewed in hindsight. Many attorneys at the trial court would look back and say, yes, maybe I should have done something different. But Strickland is not judged that way. Strickland is judged on an objective standard, and this court is not supposed to look back in hindsight and say, oh, what should he have done? The question is whether there was deficient performance and prejudice. But here, actually, and Judge Wilkinson was touching on this earlier, the standard is doubly deferential. So that the court shouldn't even really be taking the Strickland analysis head on. The question is, did the West Virginia Supreme Court of Appeals unreasonably apply Strickland? And here,
But he thought it would be based, the prosecution would be based on the trial, the threat, right? And that would require a deadly weapon. That part.
Respectfully, Your Honor, two things on that. One is that actual knowledge is not the standard. It's actual notice. And when we're thinking about actual notice, you look at the objective facts. So it's, what did the indictment say? What were the facts on the ground? And
The indictment told him what was going to be the basis and the theory of the prosecution. Now, I know your point is that he just said Section A, and A does both. But you laid out in the indictment what your theory was going to be, correct?
I understand, Your Honor,
And that's
yes.
what his understanding was, right? And you're saying his understanding was too narrow because it covered all three ways, right? Isn't that your theory?
I'm saying that
Isn't that your theory, that he should have known it because that section covered all three ways to commit the crime of first-degree robbery? Isn't that right? Isn't that what you're saying?
I'm saying that the petitioner had actual notice. In a strict sense, yes, from the indictment itself. Count 3 charged Section 12A, which refers to both of the two alternative means. And so that, in a strict sense,
But he thought you were going to proceed on just one. It's not a trick question. That's what he said. And he thought so. But instead, you said, oh, no, but all three are contained, and therefore, that's what the court told him, the jury. You can do it on either one. Even the one that required a gun, and there was no evidence of a gun, was there?
there was no evidence of a gun.
But he told him you could do it on that one, too.
I don't think that the trial counsel in the habeas proceeding ever testified that he thought that they were going to put on evidence of a gun.
No, not the evidence of a gun.
Or-
The point, though, is you would have to, what he thought, that you were going to proceed on that because that's what it said, a threat.
Trial counsel actually acknowledged that the assault, that he knew that the violence was an issue because of the assault charge. The assault charge says that the assault was committed in the course of the felony.
Well, in this kind of case, the question is simply, was there an impermissible variance or was there not? And I thought the case law was pretty clear that when the indictment was for an offense and the conviction was for the precise offense identified in the indictment, that there was no impermissible variance, notwithstanding some disagreement that surfaced in the evidence about whether what means was employed in carrying out the offense. And you can say, well, the means was a threat, or the means was actual violence. The means is, but that doesn't really matter, because the question is, under the 14th Amendment, is there sufficient notice? And as long as the indictment correctly identifies the offense and the jury convicts on that offense, the fact that there's some testimony about, oh, but it was done this way, oh, but it was done that way, that's not an impermissible variance. It just isn't under innumerable cases.
I agree, Your Honor, and that conclusion flows straight from Stroud versus Polk, and from Barb, which I know is an unpublished decision. But those two cases, and Hartman versus Lee, those three cases in this circuit lead to that conclusion. But I do want to add one thing, that is not actually the only issue. So let's imagine that this court disagrees with me that there is an impermissible variance, that this was a fatal variance. Actually, petitioner still loses, and that's because Strickland has two prongs. There's deficiency and there's prejudice. And here, this West Virginia State Supreme Court says that, or concluded that there was no prejudice. So that was a reasonable determination. Petitioner in his brief says that he would have been entitled to a complete dismissal had his counsel raised this objection.
I suppose there's no prejudice because he was going to defend all along on the question of whether the defendant actually took the money.
That's correct, Your Honor.
And as a matter of prejudice, that's not going to change the defense one way or another. You could have, 15 forms of notice, but the defense would still have been the same. He wasn't emphasizing whether it was done by threat or violence. That's the very last thing he wants the jury to hear. He doesn't want to go before the jury saying, oh, well, I did this, I took this money from this individual just because of a threat, or I actually committed the violence, or all I did was take the money because of a threat. That's the last thing he wanted the jury to hear. What he wanted the jury to hear was that I didn't take the money at all.
That's exactly
I didn't take it at all. And that is why this whole business of notice it's a red herring. It doesn't have anything to do with what went on at trial and what trial counsel, I might add, quite soundly and persuasively wanted the defense to be. Far from an ineffective assistance of counsel defense, it was very effective to put on the defense, look, I didn't do it at all. And you don't string a lawyer up for pursuing the most effective defense at trial, and you don't say there's prejudice when there wasn't any prejudice at all because it had nothing to do with the actual defense proffered. And that's just getting to the Strickland question, and beyond that, there's the EDPA hurdle about whether the West Virginia courts muffed it that badly.
Correct, Your Honor. The prejudice inquiry that you're touching on goes both to the notice and to the Strickland prejudice prong of that test. I will just add one addition on for prejudice, and not only did the trial counsel say this wouldn't have changed anything, this wouldn't have changed my defense, we were going to attack the victim's credibility and say that he never took the money, but also, if we imagine a world in which the trial counsel did raise this objection, we get to the same outcome no matter what the trial court would do. So one option is the trial court says denied. Your objection is denied. We're going to go forth. Okay, trial proceeds as it did. Same outcome. The other option is that the trial court says, okay, I see this. I'm going to grant your objection. The trial court just would have amended the indictment. The case would have proceeded the same way, and we get to the same outcome. And that is really fatal to petitioner's case. The outcome for Strickland, you have to have a reasonable probability that but for trial counsel's deficient performance, the outcome would have been different. And so here we have trial counsel saying the defense wouldn't have changed, and we know that things would have proceeded exactly as they did.
Well, it's not quite the case because I did a lot of criminal defense work in my practice in the sense that a lot of it, if counsel was under the misapprehension that it was only one theory was going to be used, right? And then he got there and said, no, we're going to use the one also in terms of violence. And if he had prepared that way and didn't know, well, really what you do, if you only have one defense, then you'd have to file a bill of particulars, wouldn't you? And that's what you know, maybe they don't do it anymore, but when I was practicing law, if you charged like that indictment did, and I know it's only one way that I have a defense for it, I'd file a bill of particulars. And then you would be held to that, wouldn't you? Notwithstanding that you had a section that had 3 ways to do it.
I
Is that
think-
right? Am I right?
If there was a bill of particulars,
That's why he should have filed a bill of particulars.
as a former prosecutor myself, I understand the court's concern, and trial counsel did not file a
He did
motion.
not file a bill of particulars, so therefore, when he came to trial, and as he said, was surprised, it's not, Judge Wilkinson was engaged in terms of the question about whether or not it was a robbery. That's the only defense he was left with. The only thing he could do to attack all 3 ways was to say there wasn't a robbery. That's the only thing he had, because he admitted that he beat her up. That was clear. He never hid that from the jury at all.
And trial counsel was having to reckon with the assault charge as well. So the violence was going to be
I'm
an
glad you
issue.
mentioned assault. Why is that not a lesser included offense? Because the same felony was the robbery. That's a lesser included offense. You can't convict him of both. First degree and the lesser included offense, and counsel didn't even raise that.
I don't want to speak out of turn, but my understanding is that assault and first-degree robbery have distinct elements, and so it wouldn't be a lesser included.
It's not?
Not in West Virginia, I don't believe.
Oh, okay.
These proceedings were in Kanawha County,
Yes, Your Honor, in front of Judge Bloom.
Circuit Court of Kanawha County, before Judge Bloom,
Yes, Your Honor.
including the post-conviction hearing where the lawyer testified.
That's correct, Your
Judge
Honor.
Bloom heard it all. He presided at trial, and he presided at the post-conviction proceedings where the lawyer testified.
That is correct, Your Honor, yes.
That went to the Supreme Court.
Yes, Your Honor, yes. And Judge Bloom was also the sentencing judge to the extent that that matters. I do want to just briefly, in the remainder of my time, just touch on why Lucas and Coakley, the 2 cases that my friend across my petitioner's counsel brought up, really shouldn't guide the court's analysis and aren't applicable. In Lucas and Coakley, in both of those cases, the defendants was charged and then convicted of separate and distinct crimes. Here, we have 2 alternative means, and 1 crime, 1 statute that remained the same throughout. We know that these are alternative means because the statute is written in the disjunctive, so it makes this case very similar to Barb, but also because this court has the benefit of State versus Gibbs, which is a West Virginia Supreme Court of Appeals decision that makes it very clear that these are 2 means of committing the same offense, robbery. In Lucas and Coakley, they were 2 distinct crimes. And critically, I actually think that Coakley supports the state's position. And that's because the analysis in Coakley turned on the decision of the Arkansas Supreme Court that had said that the alternative means, I'll call them that, in that case, were separate and distinct crimes. Now, and the court in Coakley said, okay, the Arkansas Supreme Court has just said that these are separate and distinct crimes. We're going to accept the Arkansas Supreme Court's interpretation, even though later the Arkansas Supreme Court has clarified that these are actually alternative means. And the Coakley court suggested that had the Arkansas Supreme Court clarified that earlier on, its decision would have been different because it would have been alternative means and not separate and distinct crimes. So if Coakley is good for anything, it's for the proposition that this court should defer to state courts on the interpretation of state criminal statutes. So Coakley is a bit more nuanced than petitioner represents. I see that I have just a minute left. If there are no further questions, the state asks that this court affirm.
Right. Thank you. Mr. Byrne, you have some rebuttal time, sir.
Just very, just very briefly, Your Honors. Counsel used the word actual notice. Well, the actual notice in this case was we're charging you with committing robbery via threat of the use of a deadly weapon such as a firearm. There's never been any evidence of that anywhere. The actual notice he had when he went to trial was of that charge. And so if the question is actual notice and notice under the due process clause, which trumps all of the intricacies of West Virginia law in terms of what we're talking about here, if this indictment had been returned and just said, commit first degree robbery, here's the citation, then I think this is a different case. But the state chose to narrow it. And once they do that, they cannot then turn around and say, well, we actually were charging all these offenses. I wanted to return to Judge King. You mentioned sort of the interaction between counts 3 and 4. The fact that he was also charged with assault does not necessarily pull the assault into the robbery count unless it's specifically there. So I don't think that gets the state where it needs to go. If there are no further questions, we'd ask that you reverse the district court and vacate Mr. Richardson's conviction.
You okay?
I'm fine.
Thank you, Your Honors.
We thank you. Did you want to take a recess?
I'm great.
We'll come down and brief counsel, and then we'll take a brief recess. hear LM v. Graham and Mr. Sheldon.
May it please the court, John Sheldon for LM. LM sued Graham for malicious prosecution. Graham moved to dismiss, and the district court erroneously granted the motion to dismiss. And LM has appealed that motion to dismiss ruling. Just to note, there were a lot of other plaintiffs. There was 2 other plaintiffs. There was a lot of other defendants. This does not involve any of them. LM and Graham is all that this one involves. LM alleged in his complaint that Detective Graham learned that he, LM, had a complete alibi. Learned it from staff at the school, that he was in music class, not in the gym where the assault occurred. Nevertheless, Graham provided the judicial intake officer an incomplete and false set of facts in support of Graham's request for an arrest warrant. LM was arrested, and then the Commonwealth moved to dismiss with prejudice, noting LM's complete alibi that he was in another class. That is sufficient to survive a motion to dismiss for malicious prosecution. LM needed to allege cause. Graham would have been protected if he had revealed all to the judicial intake officer, but he didn't. He misled the officer, we alleged, by providing an incomplete and false set of facts. That is, he did not inform the judicial intake officer of the complete alibi of LM, that LM was in a music class.
One question, when you went before Mr. Graham, I guess, or LM went before the judicial intake officer, did you provide the alibi to the judicial intake officer?
Judge
in
Wilkinson,
the proceedings before the judicial intake officer?
Judge Wilkinson, in Virginia, in a juvenile a detention petition, that's an ex parte event in which LM was not aware and did not participate. It was an ex parte proceeding in which Graham went to the judicial.
But I need you to answer my question directly. Was this alibi offered to the judicial intake officer? And I gather your answer is no.
No.
Was there an opportunity to provide that alibi to the judicial intake officer?
No.
Why was there not an opportunity if you'd wanted to?
Once you were detained pursuant to a juvenile petition, you go to court. He did go to court, and he got a dismissal. He was detained overnight, went to court, got a dismissal, Judge.
But the proceeding before the judicial intake officer obviously had a good deal of bearing on any kind of future suit like this, any kind of future malicious prosecution suit.
Judge Wilkinson, perhaps I don't understand your question because we're misunderstanding the procedure. This is not a procedure at which a petitioner, a juvenile, or his attorney ever participates. There's no opportunity. We don't know of it. We're not told of it. We're arrested and we're put in jail. LM knew of this when he was arrested. When he was arrested, there is no opportunity to go to the juvenile intake officer and say, you've done this wrong. Instead, you go to court, juvenile court, and that's what LM did. He took advantage of all the procedure he had, and he won.
Go ahead.
So the causation, if Graham had given the judicial intake officer full facts, even facts that did not amount to probable cause, he would be protected because he gave all the facts to the judicial intake officer. We alleged he did not, that he misled the officer, and so he caused the detention. 1, causation. 2, seizure of LM pursuant to unsupported probable cause. We alleged that Graham learned from school officials that LM was not in the PE class. We alleged that photographs were shown to the witness And the witness said, LM is not in the photographs of that gym class, again confirming. And we allege that this alibi that Graham had learned prior to going to judicial intake, this alibi Graham learned was complete. That his school staff said LM was in a music class and could not have been in that gym class where the abuse occurred. So the seizure was pursuant to unsupported probable cause. Then the criminal proceedings, third element, were terminated in LM's favor and, not an element, but notable, terminated because the prosecutor said in her written request to dismiss with prejudice, LM has a complete alibi, he was not in the class. That's all we have to allege to defeat a motion to dismiss in a malicious prosecution case. The defense, well, let me start with the district court, really relied heavily on that Graham was not the cause of the detention of LM. And of course he was. Of course he was. This court has many cases, and Evans v. Chalmers is the most apropos case that this court has that says that a police officer is absolved of the cause of an arrest when he provides full and fair information to a judicial officer. Even if it's wrong, even if it doesn't amount to probable cause, that officer is protected when he provides full information to a judicial officer. In this case, we clearly alleged that Graham did not. He misled he misled the juvenile intake officer by failing to provide this complete alibi of LM. If he had provided the complete alibi, then LM, well, first, if he provided the complete alibi, we believe LM wouldn't have ever been arrested. But Graham would have been protected if he had just done that, and he wouldn't have been the cause. But he was the cause, and the district court was wrong not to give credit to this court's case, Evans v. Chalmers. Your Honors, unlike the previous cases you've had where there was a habeas case with a trial, there was summary judgment in 1983, this is a motion to dismiss. It's simple. A malicious prosecution allegation is simple. We obviously made it. The court's mistake is obvious that it said that Graham didn't cause the detention. The court is obviously wrong because we allege Graham misled the intake officer by failing to provide this alibi. And we'd ask, if you have no further questions, that you overturn the decision of the district court and send this back. Thank you.
Good morning. May it please the court, my name is Heather Bardot, and I have the honor of representing Detective Jonathan Graham this morning in connection with the appeal before you. As counsel for LM indicated, Detective Graham has been sued by LM, a juvenile, for malicious prosecution under state law and under 42 USC section 1983, which is treated as a Fourth Amendment seizure claim. Detective Graham challenged the claims by filing a 12B6 motion to dismiss, and the district court granted that motion on 3 grounds, finding that there were probable causes for the charge that was brought against LM, that Detective Graham was entitled to qualified immunity, and that the allegations in the complaint did not establish the causation prong for a malicious prosecution claim. LM challenges each of those findings, contending that the district court's decision should be reversed. I would submit that the appeal is without merit. What I think is interesting, as has been done in briefing and as was done in briefing below, is counsel for LM alleges facts that are not in the complaint to try to convince the court to reverse the district court. In this particular case, what happened was there was a complaint that was filed which clearly had a misunderstanding of how things proceeded. But fortunately for my client, that complaint cited to a number of things. It cited to the recorded interview that was done of the victim, YA, and it relied upon it. And it cited to the statements that were given by the child who brought to the attention of the school that YA was being sexually abused by LM and 2 others. And it cited to it. And it cited to the alleged charging documents by Detective.
The schools have a terrible problem of bullying. They have a terrible problem of sexual bullying. And you read accounts of that all the time. I am concerned that if we reverse here, we're making it much more difficult for school systems and others to address problems which occur on school grounds every day. And when a lot of times it may be, in fact, transgender students that are the subject of a great deal of bullying. And what you have is you have, in many cases, the authorities need to rely, it's unfortunate, but they need to rely on witnesses who are not fully adult witnesses. In this case, the witness was an 11-year-old who twice provided the information. And these, even though they're 11-year-old and the rest, they know the identity of their peers. It's not LM's identity was not a mystery to AD. And so if we dismiss, if we discount AD's advice or his report, then you're discounting all kinds of reports of students who are sexually bullied in class. I mean, in classes, and I include transgender students who are a chief target of that these days, regrettably and unfortunately.
Yeah, I'm sorry.
And as I say, you have to sometimes rely on teenagers or whatever to give you these sorts of accounts. Because you just don't have, they know who their peers are very well.
That's true, and especially in a situation like this where the allegations of the sexual assaults, and they weren't one. So, this notion that there was a complete alibi, which, by the way, the record shows wasn't even brought to the attention of Detective Graham until after he had submitted the documentation to intake, and intake had made a probable cause finding. But putting that aside, the fact that these multiple assaults over multiple occasions that were witnessed by AD happened in a locker room means that they happen in an area that's not under any kind of video surveillance. So the only thing you're going to have is witness accounts. And so what the district court had before it when it made a determination on this case was not as has been represented by counsel for LM. What the district court had before it, because it relied on documents that were central to the complaint or referenced in the complaint, were the interviews of AD and YA and additional information. And so what did the interviews from AD say? The first interview from AD gave...
Well, this is the other thing is that the victim in this case was an autistic child. And being an autistic child, he was really disabled in his ability to push and report these things himself. The autism does not give rise to free expression, and so the victim was an autistic child, and he had to rely on someone like AD who saw him being taken advantage of.
Right, and YA did not make the report. That's exactly how it happened. AD made a report to a neighbor child. That neighbor child went to YA's brother. YA's brother brought it to the attention of the school. All of that was before the court when it decided the motion to dismiss. And with that, you know, the first interview of AD happened, and AD was very clear during that interview. And he identified 3 boys, LM and 2 other boys. He could not remember their last names at that time, but he gave very particular accounts of multiple occasions of sexual abuse of YA.
And these, we're talking about the most vulnerable populations
We certainly
in
are.
in a school setting. If there are 2 more vulnerable populations than transgender students and autistic children.
Yes, Your Honor, and what I would say is that after Detective Graham got this information from AD, he didn't just go at that point and take it to the Assistant Commonwealth's Attorney. He had no charging power. He had to go through the Assistant Commonwealth's Attorney into intake. What he did after he got the first names of these children was he went to the school and he got photographs for kids who would have been in that particular class on that particular day, putting aside the other assaults which were alleged to have occurred. And when he did that lineup for AD during a forensic interview, because he was brought back in, AD was able to identify the 2 other plaintiffs who have not filed the appeal, and he did not see a photo of LM, but what he told Detective Graham was that LM was a kid whom he had had a dispute with earlier in the year on a bus, and he had made a report to the school that he was being bullied by LM. So what did Detective Graham do? The responsible thing. He went to the school and he said, can you tell me who that kid was that the report was made by AD earlier in the year? And when the school identified him, it was the kid with the same first name that AD had identified.
He didn't just fly off the handle. I mean,
Absolutely not. And
it
so,
was much, as the district court realized, this was much more deliberate. And he went about it methodically.
right, and so even that,
I just want to say that I do not want the law to leave autistic children and transgender children, who are the chief targets today of sexual bullying in schools, and I do not want to leave them defenseless by saying that someone like the defendant in this case could not, despite the steps he took, and despite also the fact that he relied on a peer witness. They have to sometimes. It's the peers it's the 11-year-olds and 12-year-olds who understand what's going on among their peers.
right,
And so I just don't think you can dismiss it by saying, oh, AD was only 11 years old. And they know who their peers are, and they are able to spot these kinds of things where disadvantaged children are being taken advantage of.
right. And even after AD had identified the 3 boys, it was thereafter, and the record is clear on this, that YA was then brought in, and he wasn't even interviewed by Graham. He was interviewed by someone who is a professional trained to interview young children who have some disability and need special kid gloves. And during that interview, you know, YA had difficulty expressing himself, but he was able clearly to say that when he was in the locker room, there were a number of boys who were, and this is the term he used, SEXing him. And that's the way he referred to it, which is why you'll see it that way in the briefs. And he was asked, who are these boys? And he goes, I don't know their names, but AD can identify them. Well, AD did identify them. And so that's the information. That's the totality of the information that the record before this court clearly shows that Detective Graham had. And with that information, having very positive IDs with very horrific sexual harassment, holding this boy against the wall, fondling his genitals, taking him into locker rooms where he'd go in, closed stalls where he would go in with clothing on and come out with no clothing on his bottom half. He took it to the Assistant Commonwealth's Attorney and he said, here's what I have. He was then directed, Detective Graham, to take it to juvenile intake, and that was it. Detective Graham did not charge these boys. He had no authority to under 16.1-260 of the Virginia Code. It was the juvenile intake officer and the juvenile intake officer alone who had to make the probable cause determination and file the petitions. And I would note that in the pleadings, in the complaint before the court below, there's no allegations such as what you hear here today, that Detective Graham lied to the juvenile intake officer or provided incomplete information to the juvenile intake officer. There's no mention of a juvenile intake officer at all in the pleadings.
All I know is that when you have an autistic child and on top of the autism, he has been subjected to the kind of heinous acts, and to read exactly the sexual abuse to which this person was subjected. Any initial problems he had by virtue of his autism were compounded by the trauma he suffered in what were absolutely heinous acts of sexual assault. And the defendant here, as a district court recognized, did not just fly off the handle. He was pretty careful about it. And this, to say that this is a malicious prosecution, there's nothing malicious about it. He was trying to make sure that a kid got, that the bullying stopped and that a signal was sent. We don't do this to our fellow students.
Right, and so, if Detective Graham had made a probable cause determination, which he did not, because that was not his role, he was not the charging officer, but if he had made a probable cause determination under the law, under the Cayley case, which is 571 U.S. 320, all that means is that there had to be a fair probability that the crime had been committed. It is not a preponderance standard. It is not a more likely than not standard. The Texas versus Brown case out of the Supreme Court makes that clear. The U.S. versus Humphreys case out of this court makes that clear. Is there a fair probability? And it's not a weighing of the evidence. It's not a credibility determination. It's like, is there evidence to show that this crime had been committed? And so at the time he took his file to the juvenile intake officer, I would suggest that it is impossible not to find that there was a fair probability that this crime had been committed by LM. You've got an eyewitness who has identified him specifically. He has said that this was the kid he had a problem with earlier in the year. It has been satisfied through the school system, who has no dog in the fight, who that kid was. The crimes that were described were sexual in nature. There's not even any dispute about that. And it's not a high bar, this probable cause determination. And so if down the road additional information is learned, defenses are raised, there's other evidence that comes into play, that's fine. But it doesn't defeat the probable cause determination. So I would submit that the district court's determination on that point was correct. The qualified immunity ruling followed from that decision. On this causation issue, again, I would submit that the district court got it right. The allegation or the argument that we now hear from the plaintiff is, well, causation isn't severed if the allegations are that Detective Graham lied to juvenile intake. Again, I would point you all to the complaint itself, and you will nowhere find, as the district court held, that allegation in the complaint. The complaint, which was considered in addition to the documents, the extrinsic documents that the court found that it could consider, clearly shows that Detective Graham made no probable cause determination. He took his file to the juvenile intake officer. There's no allegation that he lied to that person or pressured that person, because the complaint didn't even understand how the process worked. And when he submitted his file to that person, they made the determination and they filed the petitions. And so I would submit the district court got it right when it found that Detective Graham didn't have any control over the decision whether to prosecute or not. He was not a proximate cause of that at all. And so I would submit that there's nothing that was erroneous about the district court's decision in this case. There was probable cause.
Do you have anything further?
No.
Hold on, let me just see if my colleagues have some
Yes.
questions. Bob, do you have questions?
Fine.
Chief, do you have questions?
Thank you.
We don't have any questions.
Thank you.
May it please the court. I don't think there's any doubt that anybody involved here thinks the 11-year-old was correct. Everybody knows, and Graham knew, and we allege that Graham knew, that the 11-year-old had falsely accused LM of bullying previously, falsely accused. We allege that Graham learned that the 11-year-old falsely accused LM before he went to the judicial intake officer. JA 20, paragraph 30 to 32. We alleged, this is completely contrary to Graham's counsel, we alleged in our complaint at JA 24, paragraph 53, that Graham learned from the school officials after the 11-year-old went to him. Graham's counsel told you that then Graham methodically went to the school officials. He did. And what did he learn? Before he went to judicial intake, we alleged in our complaint. We alleged that Graham learned two things. He didn't rush, he was methodical. Actually, he learned three things. He learned that the 11-year-old had falsely accused LM previously, one. Two, he learned that there's a picture of the kids in the PE class. He brought that picture to the 11-year-old, and the 11-year-old identified the other two kids, but not LM. Three, Graham was methodical. He didn't rush to judgment. He learned from school staff that LM was in a music class at the time of this PE class and couldn't have been involved. And we allege very clearly, JA 20, paragraph 31 to 33, JA 24, paragraph 53, that Graham learned all this prior to going to judicial intake, went to judicial intake and omitted this. I did not get that from Graham's counsel's argument, that she told you that Graham learned all this in his methodical investigation prior to going and getting the arrest petition. And that's what we allege in our complaint. And I just want to give you a small bit of background. This was a juvenile criminal proceeding at which we, as later counsel, had no access to anything. We have still had no access to the juvenile criminal proceeding. We have had no access to school officials. Any extra facts we learned, any recordings came after our complaint from Graham. And this is why we did not appeal, very correctly, Judge Wilkinson, the other two petitioners, because there were facts that that Graham could have found probable cause against the other petitioners, not against LM. Again, it's really surprising to me that there's a supposition in this court that we didn't put in our complaint that Graham learned all these things in his methodical investigation, that 11-year-old was a liar, that he couldn't identify LM, and that staff told Graham prior to judicial intake that LM couldn't have been in the gym and done this. Graham learned all that. That's all in our complaint on JA 20 and 24, and that's surely enough for a motion to dismiss. So we ask you to reverse. Thank you.
We'll come down and greet counsel, and then we'll proceed into our final case. Ms. Kraft.
Good morning still, and it may please the court. My name is Teresa Kraft, and I represent Ms. Redding in a case against the TSA, which is an agency within Department of Homeland Security. We pled in the complaint that Ms. Redding was discriminated against when there was a failure to accommodate her disability while she was employed at TSA. She started her employment in 2011 as a federal air marshal, which required her to have corrected vision of 20/20. She did have that. She wore glasses and/or contacts while she flew. She served in that position well until 2015, 2016. At that time, she was placed on light duty status. She was transferred from JFK and down to headquarters in Reston, Virginia. She was given a ground position, a regional coordinator. The regional coordinator position required her to fly once per month. However, during the time that she served,
What did that mean? She was required to fly once a month, so she flew as an air marshal once a month?
the position had a requirement that she would fly once a month. However,
No, but what's it mean when they required to fly?
I'm so sorry.
She's an air marshal, or
Yes.
was, but then she was transferred to a ground job,
Right.
but had to
So-
fly once a month. Was she flying as an air marshal?
Yes,
Okay.
yes, she
And
was.
and an air marshal is they're on a plane and they're
Yeah, they're
in disguise and,
essentially
and they're just as security.
Yeah, they're essentially security for the airplane. They fly undercover, for lack of a better term. They are not.
They're undercover and
they're
they're
not
flying.
announced.
And she only did it once a month after this, but she couldn't see right.
Actually, she didn't do it. Once she was transferred to the ground station at headquarters, she was accommodated and wasn't required to fly.
So she wasn't flying at all.
She was not flying
So
at
the
all.
once a month didn't apply.
Did not apply to her in that
Okay, so
position.
she no longer was an air marshal.
Technically, her title was Federal Air Marshal. That was the umbrella of her employment, but she served in field operations as a regional coordinator.
Regional coordinator.
Yes.
But that was all of what she was doing was itself the accommodation.
That's our argument. Our argument is that she was accommodated for 2 years before they forced her into a reassignment.
But they allowed her to take this position on a temporary basis. And then, but you're just saying, well, no, I have a right to be accommodated on a permanent basis, notwithstanding the fact that I can't fly. And the question is, this was an accommodation to begin with, and it was for a temporary basis. And aren't you taking advantage of the employer's generosity here?
I don't think so, because the employer had a responsibility to make a reasonable accommodation. And they determined in 2016, that it was a reasonable accommodation.
For her to be a field coordinator, or whatever you call it.
It was a reasonable accommodation to have her be in the regional, in headquarters as a regional coordinator.
And she didn't fly anymore.
No.
But how is it a reasonable accommodation to have someone in a position of a federal air marshal who cannot, due to deteriorating eyesight, fly? I mean, when you look at it on its face, air marshals should be, it's not unreasonable to require air marshals to fly. And if we were to upset what the district court did here, imagine the ripple effects through the FAM. And everybody would say, well, we can still be an air marshal and we won't have to fly because look what they did over here. They allowed her to take this temporary position, and she didn't have to fly. And then people throughout the FAM will say, well, if she got that kind of accommodation, I can't fly right now either, so I'm due this accommodation. In other words, I don't understand what is unreasonable about wanting a federal air marshal to fly. That's the whole point.
And I think that if her job position required her to fly on a regular, and by regular I mean weekly basis, the way that she had when she was stationed in JFK, then I think you're right. Saying that her 90% of her job was to fly on an airplane with a gun and be prepared to use the gun to apprehend.
And that was the job she took and what she did for 5 years.
That's the job that she took from 2011 until 2016. So yes, 5 years. Now in 2016,
But when she took the job, or when they hired her in 2011, she had an eye problem,
Yep.
and they knew it.
Oh, yeah. Her eye acuity, and this is not in the complaint,
So her eyes got worse.
her eyes did not get worse.
They didn't.
Something changed in the policy. Her medical conditions as a whole changed, but the eyesight and the reason that they cited her being medically unfit to fly
Well, how do they
was
end up hiring air marshals that can't see right?
they use the criteria that the corrected vision is the one that counts, not the uncorrected vision.
Oh, right.
So her corrected vision is 20/20.
I keep coming back to what I think was my esteemed colleague's question. How can we say to the FAM that you have to provide reasonable accommodations that do not require FAMs to fly? Because what we're getting close to is saying you've got to provide as a matter of reasonable accommodation, jobs in which FAMs don't need to fly. And that just seems to me a contradiction almost in terms.
No, I don't think so. And the distinction may be the fact that the title of federal air marshal encompasses more than just the person that flies. And so you have people on the ground who
Is that what they call the field coordinators?
yes.
So she had been an air marshal flying, and then they made her a field coordinator, and she was a non-flying air marshal.
Right. In the federal government, there are many times where the title that you're hired under.
Well, why did she need the accommodation beyond that then?
Well, the Air Marshal Service, the Federal Air Marshal Medical Services, in 2016, she went through her normal biannual medical evaluation, and they had questions and determined that she may not be fit to fly.
Well, didn't she get several accommodations? She got, first of all, this whatever this regional coordinator is, but then there was another accommodation with, I guess, requested that FAM and TSA accommodate her by reassigning her to FLETC.
And
that's another accommodation. It seems to me they're accommodating.
And that process should never have happened because
Which process?
the
never?
process of the transfer to FLETC, FLETC.
That was what she requested.
No, she was
That's the one in
told-
Georgia?
Yes,
That's a transfer to a different agency.
she was told,
She got a job with a different agency,
she was told.
and she went to train law enforcement officers, federal law enforcement officers in Georgia.
Correct. She was told by the reasonable accommodation section of TSA that because medical said you can't fly, we have to either reassign you, you will be terminated, or you go through, or you resign. Those were her three options. She already had And TSA had already started the paperwork for disability retirement when this memo came out in January of 2018.
This seems like something of a moving target to me. We want this accommodation with this agency and this accommodation with another agency and the rest. And not, if there was a shell game going on, I could understand it, but I don't see that in particular. The question is, has the employer been reasonable? And when giving her the temporary job, they were certainly reasonable, and in giving her the job with FLETC, they were certainly reasonable. I mean, it doesn't seem to me that this is a sort of a hard shell employer.
And again, we would agree that if she were told that she could no longer perform the duties of the regional coordinator, which she never was, that our confusion is, why couldn't she continue? She asked, can I continue as the regional coordinator? It is a job. It will be open, within 60 days of the date that you made this decision.
But even the temporary, quote, light duty status required some limiting flying.
But it had been accommodated for her, and it was working. She had amazing.
Okay, but the point is her eyesight deteriorated while she was in the job. But the point is that the light duty status, or the regional coordinator status, that required at least some time in the air, some flight time. And I think what was happening here was that the FAM felt that, true to its name and its mission, that they should be able to require that federal air marshals be able to fly, and then was put on light duty status. But during that time, her eyesight unfortunately regressed to the point where she could no longer fly. And so at that time, the next step that was taken, again, was to assign this individual to the FLETC, which I understand was something that she was happy with or had requested. But it all comes down basically as to whether, with the FAM is allowed to say reasonably that somebody who is a member of that, or an employee of FAM, be at least able to fly some of the time. And that's what the physical condition made it very difficult to do. It's not that I don't have sympathy for the situation. I do, but I just don't see how we can say it was unreasonable to say for the FAM to say, if you're going to be an employee here, you have to be able to spend at least some time in the air. And that's what the agency's all about.
And I'm well past my time, so if it's okay,
Well,
I'd
you've
love
got
to address.
7 full minutes for rebuttal.
Yes.
So let me ask, Bob, do you have any further questions?
I'm good.
Roger, no, thank
I'll
you.
answer those questions on rebuttal. Thank you.
Good.
Good morning, Your Honors. Kirsten O'Connor, Assistant United States Attorney for the defendants. So I wanted to clear up a couple of things that my counsel on the other side has raised here. The first is that nowhere in the complaint does Ms. Redding allege that she asked to stay in the regional coordinator position after she was medically disqualified. It's simply not in the complaint. What she asked for after she received notice that she no longer met the medical standards was a reassignment. That is the only thing she asked for. That is what TSA gave her. She identified these 2 positions at the Federal Law Enforcement Training Center, and TSA promptly transferred her there at her request. But I'd also like to clarify a few things about this regional coordinator job. And the complaint is a little unclear on this, so I'd like to go through the timeline a bit. Ms. Redding was assigned to the regional coordinator job not as light duty. There is nothing in the complaint that she was initially put in this job as an accommodation for any of her medical conditions. That was only transferred to light duty status after she was medically disqualified from flying. And that's because a regional coordinator job, as counsel indicated, is a federal air marshal job. It's a law enforcement position.
Is a regional coordinator a promotion from being a regular federal air marshal? It sounds like it might be. I'm just asking.
I'm not aware of that, Your Honor.
It's not a promotion. It's just another federal air marshal job.
That is my understanding.
But they have to be able to fly.
That's correct. So because it's a federal air marshal job, Ms. Redding was required to meet the same medical standards in the regional coordinator job as any other federal air marshal. And although she wasn't flying as frequently, in her complaint, she concedes that she was required to fly once a month. Now, when counsel says she wasn't flying once a month as a regional coordinator, that's simply not in the complaint. That, like I said, she only was transferred to light duty after she'd been in that job for over a year when she was eventually medically disqualified. And just to give a bit of context for your honors, the reason these medical standards are in place for federal air marshals.
We're here on 12B6, so we're just looking at the allegations of the complaint.
Yes, Your Honor, that's correct. And I only mean to suggest that these medical standards are specifically linked to the essential functions of this law enforcement role. And when you're asking earlier about why does an air marshal need to fly, we use flying as kind of a shorthand, but really what it is flying is where the law enforcement activities take place. That's why there are these medical standards. And so although when Ms. Redding was in the regional coordinator role, she was flying less frequently, she still had to be mission ready at all times, which means ready to go in the air to fulfill her law enforcement functions at any time. And so, of course, here, Ms. Redding does not challenge the medical standards that she was subject to. She doesn't argue they were discriminatorily applied to her, that they weren't linked to the essential functions of the air marshal
Well,
job.
the term that I thought was interesting that you used was mission ready. That even if you're not flying all the time, you still have to be mission ready. And I think there are a lot of positions in any quasi or paramilitary unit where you may not be, well, the Army Reserves, I guess, is an example of that. And you're not going to be in combat all the time, but you've got to be mission ready. You got to be mission ready. And it would seem to me to be a real blow to morale to send the message throughout the FAM that no, after all, you don't have to be mission ready and you don't have to be ready and able to fly to be a federal air marshal. And that seems to me to be just incorrect under the law.
I think that's right, Your Honor, and that's why this light duty point is important. Light duty, as you know, I'm sure Your Honors have encountered in other contexts, usually comes up when someone has a temporary disabling condition, recovering from surgery or the like. And in this case, Ms. Redding was temporarily put on light duty once she failed her physical to determine what would happen next. So she started the disability retirement process, she started the reasonable accommodation process, but the case law from this court is very clear, and Elledge and other cases, that light duty is not a permanent accommodation. Employers are not required to change the essential functions that any employee performs or to put them on a permanent light duty status in order to accommodate a disability. And in fact, I think Ms. Redding acknowledges that, because in her complaint, when she says, I was medically disqualified, I submitted my request for an accommodation, and she specifically says, I asked for a transfer because I was no longer able to meet the essential functions of the federal air marshal role. And once again, I just want to take back where I started here, which is that ultimately a failure to accommodate claim accuses an employer of refusing to accommodate someone who was qualified for the job. And here, Ms. Redding has really pled herself out of alleging that she could perform the essential functions of this law enforcement job.
You're saying she pleaded her claim away?
Yes, Your Honor. She admits she was required to fly. She admits she could not fly, and that the only accommodation she asked for was a transfer. And TSA gave her the transfer she wanted. And in fact, there are a lot of allegations in the complaint about what happened after she was transferred, but it's really all beside the point, because here TSA did what its employee requested, and I just think there's no way that you could read this complaint as alleging that TSA failed to accommodate her disability. If Your Honors don't have any further questions, I would be happy to sit down or answer whatever questions you might have.
Bob, do you have any more questions?
I'm good.
Roger, do you have any questions?
Just one, Ms. O'Connor, isn't it under this circumstance here, you're right, and I think you talk about mission readiness, and good point, but when they made her a regional coordinator, although it's under the rubric, if you will, of the overall umbrella of an air marshal, it seemed to be been a position that they found that it worked for her because she could do that job, and the occasional one time a month could do so. And they did that. It said she could, and so the question is, it seemed like below, don't we have to remand this for at least to get an analysis of whether now it really is an essential function? Yeah, you would like people to do everything, for example, like a desk sergeant. You're still a police officer. Well, you have to be ready, I guess, at some point if somebody comes through the precinct with a weapon, you're able to fire a weapon at them. But for the most part, every day you're at the desk. So once having done that, that's not what she did. However she got there, they said, that's fulfilling the job. That's a job I can do. But don't you have to have an analysis, and I don't think it's been done below, correct me if I'm wrong, as to whether this is an essential one. Is it essential to that job?
And just to clarify, are you suggesting that she would stay in the regional coordinator role without the flying requirement?
Yes.
Okay.
Yes.
Because I was going to say that I think Ms. Redding's been quite clear that she cannot fulfill that requirement.
Right.
And here, I find it helpful to step back a little bit because, like I said before, the flying it's a shorthand for law enforcement duty. This is still a law enforcement position, even though at the time she was not in the air. And so Ms. Redding is essentially asking this court to rewrite the entire nature of a federal air marshal job by exempting her from the law enforcement functions. And so, to be sure, I'm very confident that we could marshal significant evidence to support that contention, but there's plenty in the complaint here because, first of all, Ms. Redding, like I said, agrees that she was required to fly and could not, but she also...
Well, is the job description in the record here? I think all we have is the complaint you just told us.
Yes, Your Honor, that's correct. This is on a 12B6, so we can only look at the complaint. But Ms. Redding herself in the complaint suggests that she wanted a transfer specifically...
Can we take judicial notice of whatever the job description is for a federal air marshal? Or whatever the job description is for a regional coordinator?
There's nothing in the record that I can point you to at this point, but I would just note, Your Honors, that Ms. Redding herself in the complaint suggested she only wanted a transfer to another law enforcement position, and there's a lot of reasons for that related to pay and retirement benefits and other things. That's why she...
But I don't think that's in dispute, is it, that you've got to have some time in the air, and, I think Judge King said you may have pleaded yourself out of your case, but I don't think it's in dispute that a federal air marshal would be able to spend some time in the air.
That's our positions, Your Honors, because if she wanted a pure desk job, an administrative job, an analyst job, something like that, that would not be a federal air marshal position. She wouldn't be entitled to, the law enforcement pay and benefits that she gets as a federal air marshal. So she's asking this court, as Judge Wilkinson indicated earlier, to rewrite the fundamental nature of this job, which is a law enforcement job with the capability to fly. So for those
Yeah, but
reasons,
we don't know exactly what the job description is, because we don't have it before us.
yes, Your Honor, we have to look at the
We
complaint.
just have to take what the allegations are in the complaint.
Yes, and Ms. Redding says repeatedly throughout the complaint, not only that she was required to fly even in the regional coordinator role and could not, but that her various medical conditions were worsening over time. They impacted her ability to fulfill the, quote, normal duties or normal functions, something like that, of a federal air marshal. And as I said, it seems even from the complaint that she recognized that, because when she was medically disqualified.
As I understand, your position is that the complaint itself acknowledges that being able to fly is a job qualification.
That's correct, Your Honor. And even if we accept that perhaps it wasn't, which of course we don't concede, as I stated at the beginning.
The complaint says it was.
Yes, absolutely. I just mean hypothetically, even if we were to imagine that this was not an essential function, TSA gave her the accommodation she asked for. Now she's asking this court to kind of Monday morning quarterback and to say, TSA should have done something different than what she requested at the time. She does not allege that she asked to stay in the regional coordinator role without flying. She asked only to be reassigned to the Federal Law Enforcement Training Center. There's nothing else in here about another accommodation she requested. TSA gave her what she asked for. She was ultimately dissatisfied with her position at the Federal Law Enforcement Training Center, but that has nothing to do with whether TSA discharges obligations to her, which, like I said now repeatedly, was that they gave her the transfer she wanted.
But the problem, she said she wasn't qualified for that job, didn't she?
So when she went, my understanding is when she went to the Federal Law Enforcement Training Center, she had some struggles with her disability there, and that it just wasn't what she expected.
And I think she talked about qualification too, that she didn't feel like she was qualified for that job.
Correct. She does say that, and
Right.
I think it's a little complicated because here she identified the job to transfer her to. She doesn't allege that TSA's vetting of that job was improper or anything like that. She just says TSA should have transferred me to another job more than a year later when I told them I wasn't happy.
See, here's the problem. It's not you as counsel, but the problem here, it seems to me, in terms of a person who works for the federal government and doing a good job and trying to do those things, and she had visual acuity is one of the problems she had. She applied for disability.
Yes, Your Honor.
Right, from that job. And rather than telling her that things really were going well for her, it looked very promising, instead they sent her to a place that was still under the rubric of air marshal, but a place where you had only, if you had to do it, one time a month. And she went there. And then you was going to say, well, you got to be mission ready. So now you either got to go to a position that you may not be qualified for or retire. And then when retirement comes through and they say, well, we can't help you because you're no longer in our agency and you can't show that you can't do what's being done in the job that they sent you to down in Georgia. And so it's kind of unfair in the sense that she's disabled, but they cut her off from her disability. Instead, she's at a place where they knew she couldn't fly, right, in America. That's why she left the first place. But they sent her to a place under the idea, which was good, but well, you don't have to fly her once a month. You can do that. And then she was, matter of fact, didn't she say that she really wasn't even flying once a month? Am I wrong about that?
She said that today. That is not in the complaint.
It's not like, but anyway, she was seemed like she was doing fairly well. But then, of course, he said, no, the book says you got to be qualified mission ready like everybody else. So you got to go to another place where you may not be qualified for, or retire, which she had already has a retirement disability and she wanted and then she wins the battle and loses the war. That's something, to me, that's just intrinsically unfair to a federal employee, or any kind of employee, but particularly in the federal, in terms of serving our country, in terms of those jobs, and many people go through, I mean, it's just incredible sacrifice, and people who work for the courts and all those places in the federal government, to say that now that you won the disability, we sent you someplace where now we're going to enforce that what you can't do, and then send you other place where you're not qualified to do it, and when you win that, oh, sorry, you're not an economic agency, and you see, it's like the outfielder.
I completely understand your point, Judge Gregory. It certainly seems that she was, whatever information she was given was confusing to her for whatever reason. It's not exactly clear where the crossed wires happened, but I do just want to make 2 quick points. One is that there's no indication in the complaint that she or TSA thought she was not qualified for the FLETC job at the time she was transferred. This is sort of a after-the-fact suggestion that she's made. But I also wanted to flag for the court, I think it's in a footnote in our brief, that obviously Ms. Redding took issue with how she was treated at FLETC and also with how her disability retirement was processed by the Office of Personnel Management. She has sued both of those agencies separately. So she's a little bit trying to bootstrap some of those allegations into our complaint, but our complaint really is limited to whether TSA properly accommodated her at the time. And like I said, they gave her the transfer she asked for at the time. And then it was only more than a year later that she came back and said, TSA, I don't like this job you transferred me into, at which point they said, well, if you need accommodations from FLETC, you need to deal with FLETC. If you have problems with your disability retirement, that's processed by OPM. So I certainly appreciate, the bureaucratic challenge here, but I don't think it changes the actual analysis before this court, which is the reasonable accommodation process.
The question, I suppose, here is simply whether the accommodation was reasonable. And as I read it, there were 2 accommodations here, at least as far as I can tell. The first accommodation was to put her in a light-duty job. And then when what is conceded to be a requirement that you spend some time in the air, when that could no longer be met, a second accommodation was attempted, which was to go to the FLETC. There's something. So you have an agency here that has made 2 accommodations, not just one, but first for the light duty job. Then when it got to the point that you couldn't perform that because of deteriorating eyesight, and there are people who unfortunately are laid off from their jobs, court security officers, for example, they have to go through a hearing test and an eyesight test and everything. And if they can't pass the hearing test or the eyesight test, then they have to, some other arrangements have to be made. But there was the first accommodation there to be an FAM with a light duty job, and when the qualification wasn't made, then there was a second accommodation attempted. And so and that was at her request, as I understand it. And
Yes,
so,
sure.
am I wrong to look at this as a situation where there were 2 accommodations, both of which seemed to be agreeable to her, and in fact she had requested, and that accommodations don't have to be perfect, they often aren't. But there are 2 of them here, 2 accommodations, one of which she was perfectly happy with, the other of which she requested. Is that a fair view?
Like I said at the beginning, the complaint is a little unclear about the nature of the initial assignment to the regional coordinator job. My understanding was it was not initially light duty. Like I said, it was only light duty once she was medically disqualified. But the point, I think, is still well taken, that once she was performing that job just fine until her eyesight was too poor to qualify under the federal air marshal standards. She was put in light duty at that time, and then she requested a reassignment that was not subject to medical standards, apparently appreciating that she could not stay on as a federal air marshal. So I agree with you that TSA did what it should have and could have done here. Unfortunately, I see I'm over time, if I may. Yes,
I want to ask you another question.
of course.
To your understanding, you represent the government,
Yes, sir.
the two accommodations that Judge Wilkinson explained, that's the way I understood it too. Are you challenging both of them, or just you only understand there's one?
My understanding of the complaint is that Ms. Redding is challenging her reassignment as an accommodation
Reassignment where?
to the Federal Law Enforcement Training Center.
The second one.
Correct.
That was when she went to Georgia.
That's correct.
So there's no challenge to being the field coordinator and with the requirement that she fly once a month.
That's correct.
You understand there's no challenge to that. The challenge is to go to Georgia to the Federal Law Enforcement Training Center.
That is correct, Your Honor.
All right.
Yes.
And was that what requested?
Yes, she says in her complaint that she identified these two jobs that she was willing to transfer to, and TSA granted that request.
So the second accommodation was one that she requested?
Yes.
Fine.
Thank you, Your Honors. Who would ask that the district court's judgment be affirmed?
I'd like
Now,
to
do we
make,
understand that correctly now?
well, I'd like to make one thing really clear.
You're only challenging the one about Georgia.
We're challenging the way that the process between the time that she was performing her job on light duty, she was then submitting paperwork for disability retirement, and unbeknownst to her, HR and everyone had said she's eligible for immediate disability retirement. They said that in November. They did not inform her of that. What they informed her, and when they informed her, was in January of 2018. They informed her that you no longer qualify. You have to either resign.
Isn't that a different case, a question of disability determination and the rest?
But it's still here at under TSAs. There are other issues that go to other,
So
but
why isn't this a disability claim or something, if that's the case?
because everyone has said that TSA is not responsible, but they are, because they discriminated against her
Well,
on her benefits when
Well,
they
maybe
did
so,
not.
but that again is, whether TSA is responsible or not, that's a disability case, and there are lots of ways to get disability benefits, and but that doesn't seem to me to be an issue here. That seems to me to be a different cause of action.
No,
One of the things that this is, you put this as a hard luck case, and I would only say to you that every position in law enforcement, whether one is a security guard or whether one is a policeman or whatever, they have to pass annual tests. And those annual tests deal with physical ability. Here it's eyesight, but in other senses it's hearing. In other senses, in some other senses, it may be age. In other senses, it may be physical endurance or whatever. But these are simply a part of life. It's a part of growing older. And I don't understand what is unreasonable in terms of the disability statutes about what happened here. As I say, I think the whole thing is a bit of a moving target. And I think that's why I don't speak for Judge King, but it certainly has been a problem in my getting my arms around it. It seems to me that, well, we say it's this, no, it's this, no, it's that, no, it's this. And it's not really coming into focus for me.
We have always said that this is a failure to accommodate claim. Now, a component of that is the failure to.
But you complained after she went to Georgia. And that is not the TSA, that's the Federal Law Enforcement Training Center.
She complained.
That's run by another agency,
She
isn't it?
complained when she went to FLETC because she did not have the knowledge that her disability retirement had been put through and that she was going to be approved for it.
Who runs the Federal Law Enforcement Training Center?
Homeland Security.
Homeland Security. And so it's the same umbrella agency.
Correct.
All right, Homeland Security and then TSA's Homeland Security.
Right.
I'm with you.
But when it comes to TSA's approval, or the OPM's approval of TSA's disability retirement when she's been transferred to FLETC, they say no. I would refer the court to a decision, Stanley v. City of Stanford. It's a fairly new case. It came out in June. It's a U.S. Supreme Court 606 U.S. 46. It was decided in June of 2025. And that discusses whether you can bring a disability, whether you can bring a failure to accommodate claim regarding a benefit. And that's the issue at the heart of this is she did not learn that she was no longer eligible for the disability benefits that TSA had said she required until well after they had transferred her. I also take issue with the idea that she requested. She was placed in an administrative limbo, bureaucratic loophole of a memo coming to her that does not, other than a side note, if you think you might be eligible for disability retirement, contact OPM. She'd already been in contact with OPM. TSA had already been in contact with OPM. TSA knew that her disability retirement was in the process of being approved, and yet they still told her, resign, be terminated, or retire. She's not eligible for retirement, she's not old enough. She resigns, she loses the benefit. She's terminated, she loses the benefit. So this new case regarding whether or not the benefits can be is, I think, instructive on this course and may offer some clarity on the issue. We've always raised the fact that she admitted in the complaint.
Why wasn't this new case brought up in your initial argument?
I believe that these were briefed before then, but in all honesty, I found it
So to give,
3 or 4 days ago.
Give the other side a chance to reply?
I'm happy to do a 28J.
No, usually the time for that was in your initial argument. You see, deprive the other side of a chance to reply when you throw in something on rebuttal. That's what's happened here.
And again, it's a fairly new case, and I believe that the majority of the briefing was done before. I have it in April is when we did the briefing.
Yeah, it still goes to the point that I don't understand why this was brought as a Rehabilitation Act claim when there seem to be other avenues that speak more pertinently to it. And in the future, I think if you want to bring this kind of thing up, fairness, basic fairness to the other side would have you do it in your initial element, in your initial argument, and in order to give the other folks a fair chance to respond to it, which they haven't had here.
Understood. Thank you so much. My time is up. If there are no more questions, we would stand on our briefs and ask that you reverse.
We will adjourn court and come down and greet counsel.